California Labor Code Section 2870 protects certain employee inventions against claims to those inventions by the employers. And this section states, any provision in an employment agreement which provides that an employee shall assign or offer to assign any of his rights in an invention to his employer shall not apply to an invention that the employee developed entirely on his own time without using the employer's equipment, supplies, facilities, or trade secret information, except for those inventions that either relate at the time of conception or reduction to practice of the invention to the employer's business, or actual or demonstrably anticipated research or development of the employer, or result from any work performed by the employee for the employer. So essentially, this section protects the work, the inventions that employees create on their own time with their own resources from claims of the companies, of their employers. So let's take an example. Let's say you are a software engineer and you want to design a product. You want to design a new software or a new tool that you believe could be very successful and sold for profit. How do you make sure that the company for which you're working at the same time, where you're employed as a regular employee, how to make sure that they cannot claim a share to the profits or to the rights to your product? Well, you have to make sure that you follow a few simple but important guidelines. First, whatever work you perform to create that product, you should do on your own time, meaning outside the work hours. If you're supposed to report to the office for your regular job, make sure that you work on your product not in the office, but outside the office, at home, at a coffee shop, wherever else. If you work remotely at your regular job, then it might be a better idea to work on your own product on a separate computer. Make sure that you don't involve other employees of the company where you work in helping you with your product. For several reasons. Number one, it breaks that separateness between your job and working on this product. And number two, you never know what these employees are going to tell to your manager and to your superiors, and how it's going to affect your relationship with your employer, and also any potential rights that they might have. Because the moment that you ask your coworkers to help you out, it almost looks like you don't have that separation. You don't have that full separation anymore between your regular job and the work that you do on your product. So if you need help, hire people who have nothing to do with your company. Ideally, you should be using even a separate email address so that it looks like this project that you're working on your own is completely separate. You should not be using any resources. You should not be using company computer, company tools, or any software that licensed to the company when you're creating your own product. Because the reality is that the more successful the product that you create will be, the more noticeable it will be to everyone, including your employer, and the more tempted they will be to try to claim certain rights to that product if it is at all possible. So the more separation you can create in time, in space where you work, in tools that you're using, and the people that you're involving, and in the manner of communication, the more separation you can create between the two, the safer you will be from any such claims. And this section is very important because it says that even if your handbook at work, even if your employment agreement states that your company might be entitled to anything that you invent while working for them, basically this section, Labor Code 2870, it makes that clause in your agreement unenforceable, assuming that you follow these simple tips that I just mentioned. And the exceptions are also very important. The exceptions are that if you are working on a product that you gain knowledge of or you are able to create because of the knowledge acquired while working at this company, and the two are sufficiently related, then your employer might have a claim to your product. And also, if you perform a certain research at your regular workplace and then it's clear that research led you to creating the product that you claim to be your own, it might also be a problem, and your employer might also have a claim to that product. Now, every situation is different. Every product is different. Every relationship between employees and employers is different. So, of course, if you're thinking about creating a product and you want to make sure that your long hours of work and all the energy and all the resources that you invest in your product, they go to you and you don't have to deal with claims, you should definitely speak with a competent, experienced attorney who can look at the whole picture, your specific picture, not any picture, and make sure that you avoid making common mistakes and you do what needs to be done in your situation to avoid any claim disputes with your employer or with any other company for that matter. Thank you.